So we're looking at the first of the provisions for prior testimony, and when it's admissible as substantive evidence, something we'll get into later, the difference between substantive and impeachment testimony. But we're looking at when prior statements are admissible as substantive testimony, when they are inconsistent with what the witness on the stand is currently saying. Now, in our later cases, we'll get into the requirements for oath and other proceeding. But right now, we're looking at the Truman case as the first two cases that addresses that fundamental definition of inconsistent. What does the word inconsistent mean? So in the Truman case, Truman and his son had both been accused of being part of an arson. Truman, the father, owned a business property that he was unable to rent, and Truman Jr. set fire to it to collect the insurance money. And the question is, and Truman Jr. had agreed to cooperate against the father and had actually testified against him in the state trial that was dismissed. So then the federal government picks up the case and prosecutes Truman Sr. and uses Truman Jr. as a cooperating witness. So when at Truman Sr.'s federal criminal trial, the government calls Truman Jr., his son, to the stand and asks him to testify about what his father had done, he now refuses. And so the government seeks to bring in the prior state trial, because the case had gone to trial in state court against Truman Sr., and Truman Jr. had testified against his father at the prior state trial. So that satisfies certainly all the requirements of proceeding. It was another trial where Truman Jr. was under oath. And the question is, in the Truman case, whether his prior testimony in the state court proceeding is now inconsistent with what he's saying at his father's federal trial. Well, it's problematic because he's not actually saying anything. He's refusing to testify. So the question then is nothing inconsistent with something? Is a refusal to testify inconsistent with the testimony that was previously given? And the court in Truman says, yes, it is. So when you have prior testimony of a witness who you bring to the stand, who says they can't remember or refuses to testify, the Truman case stands for the proposition that so long as that person is on the stand, he or she is subject to cross-examination and is testifying inconsistently with the prior testimony, even though the person is refusing to testify at all in the current case. So nothing is inconsistent with something.